Hello, everyone. This is Gaston from Markman Advisors, here to talk to you in today's Markman Minute, where we take a look at interesting stories at the intersection of patent litigation and investing. This week's Markman Minute will be found at mimesislaw.com. You can find the rest of our content there on a weekly basis under the Intellectual Property tab, in addition to this minute and prior minutes that we've recorded. Mimesis hosts a whole variety of content related to prior newsletters that we put out, the Markman Note, on a weekly basis, as well as a lot of other great content focusing on other areas of law. So for this week's discussion, I wanted to focus on a very interesting development that really hits at one of the core issues that seems to be driving social justice-oriented folks nowadays, and that's the problem of runaway drug pricing. In the interest of trying to get lower drug prices, we've seen a number of different strategies employed. But I think there was a filing recently that raised some very interesting questions, and if successful, could prove to become a real challenge for pharmaceutical branded companies. So the situation I wanted to talk to everyone about is a class action lawsuit that was actually filed on behalf of two union benefit plans. And in the class action lawsuit was filed against Novartis, which is obviously a large branded pharmaceutical manufacturer. And it revolved around a very interesting patent situation with respect to Novartis's patents protecting a drug called Gleevec. Now, Gleevec is quite frankly one of the most important cancer drugs to have been developed in the last decades. It's a very effective drug for the treatment of leukemia and other cancers, and has both done a lot of good for patients and also contributed very significantly to Novartis's bottom line, to the tune of billions of dollars a year in sales. Now, Gleevec, as with most other drugs, is protected by a variety of patents, and the way most drug patents are associated with a particular drug is through the FDA's Orange Book, which lists the particular patents that would be protecting a drug like Gleevec. So Gleevec's main protection actually came from what we call a compound patent, which is actually a patent directed to the molecule or compound that makes Gleevec a novel cancer-fighting molecule. That patent, however, is actually set to expire on July 4th of 2015, so this week. Other than the compound patent, Novartis also was able to secure some what we call method of use patents or follow-on patents to protect different ways of administering Gleevec to patients. And one of those patents was added to the Orange Book with an expiration date of 2019. So in effect, if you think about it, the main compound patent for Gleevec protects the drug through 2015. And then Novartis, in a move that's quite typical of large branded pharmaceutical companies, looks to add a follow-on set of patents to extend exclusivity another couple of years. So all this is fairly typical practice in the industry. So Novartis adds a 2019 expiring method patent to the Orange Book for Gleevec. Back in 2013, in another move that's very common, one of the large generic pharmaceutical companies called Pharma actually filed a declaratory judgment case against Novartis, arguing that Novartis's patent was invalid, meaning the 2019 expiring patent was invalid and should not bar Sun from offering a generic to Gleevec. Now, the timing is actually fairly standard. If you think about it, filing a case in 2013, due to the normal length of time for a district court process, it's not unheard of for a case like that to take a period of 2 to 3 years. So Sun's timing in filing the declaratory judgment case was clearly directed to trying to knock the patent out of the way so that they can enter right when the 2015 compound patent on Gleevec would expire. So all this is fairly typical under the Hatch-Waxman rubric that governs the interactions between branded pharmaceutical and generic pharmaceutical companies. Then, in an interesting development, but again, not an uncommon one, Sun and Novartis settled. And as part of the settlement, Novartis agreed that Sun can offer a generic version of Gleevec 7 months from now, February 2016. So in effect, Novartis agreed in an effort to keep its patent alive to reduce the 48 months of exclusivity that a 2019 patent would normally have given them, reduce it to a 7-month period of exclusivity, at least with respect to Sun Pharma. So there's 7 months now where Novartis will continue to enjoy premium pricing as the branded pharmaceutical company with respect to Gleevec. Now, Gleevec is not a cheap drug. It's something along the lines of $9,000 a month. In a very interesting development, this class action case was filed on behalf of 2 unions that would be paying for Gleevec for their members. And the union's argument is a simple one. They are saying that, look, Novartis and Sun are somehow colluding to unlawfully extend, to get around the antitrust statutes and unlawfully extend Novartis's monopoly by a period of 7 months. And the union shouldn't have to pay the inflated price of Gleevec when there's no generic competition for that period of 7 months, and that's going to be the damage. In response, Novartis makes some very strong arguments as well. They say, look, all we're doing is adding a patent to the Orange Book, which is proper, that when patents issue from the patent office, they carry with them a presumption of validity, and no one has demonstrated that this patent is invalid in any way. And there's nothing wrong with us settling with a generic competitor in order to allow a generic competitor to come to market a little bit earlier than it normally would be allowed in exchange for avoiding a challenge to our patent. So, this is an interesting situation to look out for. I imagine that Novartis is going to file a motion to dismiss. I also imagine that the lawyers representing the union are going to vigorously oppose that motion. And it's going to be very interesting to see whether or not this type of effort to force branded pharmaceutical companies to offer their drugs at lower prices and stop using patents as a means of protecting their monopoly profits is going to get any traction. That's it for this week's Markman Minute. Again, my name is Gaston from Markman Advisors. You can find all our content at mimesislaw.com under the Intellectual Property tab. See you next time.